Welcome to the Municipal Court of the City of Lilburn. My name is Charles Barrett. I am the Chief Judge of the court. This court handles traffic offenses, city ordinance violations, and a limited number of state law misdemeanor offenses, including driving under the influence of alcohol or drugs. Traffic offenses are misdemeanor crimes under the laws of this state and typically have a maximum allowable sentence of up to a $1,000 fine and 12 months in jail on each count. City ordinance violations have a maximum sentence of a $1,000 fine and 90 days in jail. Some offenses have lesser maximum penalties, and some offenses have mandatory minimum penalties. You will be arraigned today. Arraignment means that you are here to answer the charges against you by entering a plea of not guilty, guilty, or nolo contendere. If you enter a plea of not guilty, a trial will be scheduled for you at a later date. If you enter a guilty plea or a nolo contendere plea, you will receive your sentence today. The usual sentence in this court is the payment of a fine. However, depending on the offense with which you are charged, along with your prior driving or criminal record, you could be sentenced to probation, community service, driving school, alcohol or drug programs, or even jail time. Please be aware that conviction for a fourth DUI offense within 10 years is a felony conviction. State law requires the court to collect a surcharge on each fine in each case, except for some seatbelt violations. Therefore, the total amount you may have to pay will include surcharges which are not kept by the city. If you are sentenced to probation, you will have to pay probation service fees in addition to fines and surcharges. A guilty plea means that you are admitting to everything you have been charged with. If you plead nolo contendere or no contest, you are simply not contesting the charges against you as opposed to admitting them, although nolo contendere pleas are considered to be convictions for many purposes. The sentence for a nolo plea can be the same as for a guilty plea, and most nolo pleas to traffic and other criminal offenses are reported on your driving or criminal histories. Under some circumstances, a nolo contendere plea may prevent the suspension of your driver's license. For example, if you are charged with no insurance, racing, driving on a suspended license, or possession of marijuana, your license will be suspended if you plead guilty or if you are found guilty at a trial. A nolo plea may prevent these suspensions. However, you need to be aware that there are certain offenses that will suspend your license even with a nolo plea. These include a second conviction within the previous 5 years on all of the charges I just named. Also, a suspension will occur for any guilty or nolo contendere plea on a driving under the influence charge. If you are under 21 years of age at the time of conviction, even a nolo plea to the charges of hit and run, leaving the scene of an accident, racing, fleeing or attempting to elude a police officer, reckless driving, purchasing or misrepresenting age or identity to purchase an alcoholic beverage, DUI, or any offense for which 4 or more points are assessed against your driving record will cause the suspension of your license even if you plead nolo contendere. Therefore, speeding more than 24 miles over the speed limit will result in the suspension of your driver's license if you are under 21 when you come to court. Also, if you are under 18 years of age and if you accumulate a total of 4 or more points in any consecutive 12-month period, your driver's license will be suspended. A nolo contendere plea will count towards this suspension. Please keep in mind that a nolo plea does not have to be accepted by the court. The municipal court clerk reports most matters involving traffic offenses to to the Georgia Department of Driver Services, which then adds them to your driving record. Whether or not points are added to your record is up to the Department of Driver Services and not the court. Also, whether or not your driver's license is suspended or revoked is up to the Department of Driver Services, subject to your right of appeal and not the court, although the law requires the court to confiscate your license in some cases. In most cases, it is not necessary that you receive formal written notice that your license is being suspended in order for it to be a valid suspension. With certain offenses, such as DUI, you are presumed by law to know that your license will be suspended upon conviction. Also, your driver's license is never automatically returned to you after a period of suspension has ended. You must apply to the Department of Driver Services for its return, pay the reinstatement fee, and provide whatever documents that department might require, such as proof of insurance or a certificate from a driving school, before the suspension is officially over. If your license is suspended, do not drive again until the state of Georgia has given written permission for you to do so. The municipal court is a court with criminal jurisdiction, and therefore it does not determine who is at fault for a traffic accident. As in a lawsuit, that is a civil matter for a court with civil jurisdiction. If you wish to contest the charges against you, you will need to plead not guilty and return another day for trial. In this court, you have certain guaranteed rights. You have the right to a speedy trial by a judge or a jury. However, in most cases charging city ordinance violations, there is no right to a jury trial. You are presumed to be innocent. The case against you must be proven by the city beyond a reasonable doubt. You have the right to confront the witnesses against you and ask them questions. You have the right to compel the witnesses to appear in court by subpoena. You have the right to produce witnesses in your behalf and produce exhibits such as pictures or drawings subject to the rules of evidence. You may testify yourself if you wish to, but you cannot be forced to. If you are not a citizen of the United States, the law of Georgia requires the court to inform you that whatever happens in this court could affect your immigration status. Everyone has the right to be represented by an attorney, either one hired by you or appointed by the court. If you are legally indigent and if the offense with which you are charged meets the legal standards requiring appointed counsel, the court may appoint an attorney if you request an attorney and if you truthfully complete an application form. State law requires the payment of an application fee unless waived by the court. You may make a request for an appointed attorney when your name is called. If you are dissatisfied with the judgment of this court after a trial, you may appeal that decision to the Superior Court of Gwinnett County within 30 days if it involves a traffic violation. If you are found guilty of any other offense by the court, you may challenge that conviction by filing a petition for a writ of certiorari in the Superior Court of Gwinnett County within 30 days of the judgment of this court. You have the right to have a lawyer represent you in all court proceedings, including a trial. If you represent yourself at a trial or at any other court proceeding, you will be held to the same standards as a lawyer. Lawyers have been trained in the rules of law and evidence, and if you represent yourself and handle your own defense, you may not understand the rules used in court. There may be possible defenses that a lawyer may know how to raise, such as defects in the citation or accusation, misidentification, alibi, or a reliance on the presumption of innocence, and you may not know enough to properly raise those defenses at a trial or at some other court hearing. At a trial or at some other court hearing or proceeding, you may wish to call witnesses to testify. You may wish to question witnesses who testify for the prosecution, and you may not know how to do that properly. You must take all necessary steps to preserve all issues that can be used in any appeal, and while a lawyer may know how to do this, you may not. The decision to testify in a criminal trial is a critical one that someone representing himself or herself will have to make without the expertise of a lawyer. Your decision about whether to waive your right to a jury trial is also a critical decision that you will have to make without the benefit of a lawyer's training and advice. For those of you that are placed on probation, the court has employed a private probation company. You will meet with a probation supervisor following your sentencing. While on probation, you are expected to abide by the terms and conditions of probation, including payment of fines and surcharges, completion of any programs, community service, and any monthly probation fees as may be assessed. Each one of you was given a waiver of rights form when you checked in today. If you intend to plead guilty or nolo contendere today, you must read, understand, and sign that document and bring it with you when your case is called by the court. You have the option to speak with the solicitor, who is the prosecuting attorney, about your case before your case is called by the court. When the solicitor calls your name, please let him or her know if you want to discuss a possible resolution of your case. When your name is called by the court, please come forward and, when asked to do so, state your intention to plead not guilty, guilty, nolo contendere, or make some other announcement such as a request for a continuance or for an application for an appointed attorney. Thank you for your attention. Welcome to the Municipal Court of the City of Lilburn. The civil calendar today deals with appeals from the citations generated by what are commonly known as the red light cameras, in connection with which citations are generated by automated cameras and lasers located within the City of Lilburn. This is not an arraignment calendar, as this is not a criminal or traffic court calendar. There is a solicitor present today representing the city. The court will provide an interpreter for any non-English speaking person who needs such services. Let me emphasize that the citation that you received is not considered to be a criminal citation. The appeals that will be heard today are considered to be civil cases, not criminal cases. The City of Lilburn issues these citations under its city ordinance. If one of the city's police officers had observed you traveling through the intersection after the light had turned red and then he or she had issued a ticket to you, that would be considered as a criminal traffic citation. If you were convicted of the charge, then that disposition could be reported to the Georgia Department of Driver Services, and you could receive points on your driving history. It could also be reportable to your insurance company. But because your citation was issued by an automated system, the City of Lilburn is not prosecuting these cases as criminal citations, and instead is proceeding on a civil basis. Since this is a civil proceeding, please be aware of the important differences between a civil proceeding and a criminal prosecution. A conviction in a criminal or traffic court could result in up to a $1,000 fine or even a jail sentence. In this court, the fine, otherwise known as a civil penalty, is $70. I reiterate that, as this is a civil case, court adjudications of liability are not deemed to be convictions for purposes of your permanent driver's history, and cannot be used for insurance purposes in determining your premium rates. As this is a civil case, the burden of proof on the city in these cases is by a preponderance of the evidence and not beyond a reasonable doubt, which is a higher standard of proof as would be required in a criminal case. Also, as this is a civil proceeding and you are not subject to the more severe penalties or jail time pursuant to a criminal conviction, the court cannot appoint an attorney to represent you even if you are unable to afford an attorney. The Lilburn City Ordinance defines the violation in terms of where you must stop prior to entering the intersection when the signal is either a steady circular red light signal or a steady red arrow signal. The intersections where the automated cameras and lasers are located contain a clearly marked stop line, or as it is also referred to as the balk line. This is a wide, solid white line in the lane of traffic which marks the spot where you must stop to avoid entering the intersection and consequently violating the ordinance. If you drive across the stop line or balk line after the light has turned red, that conduct alone constitutes a violation of the ordinance. You do not have to actually run through the intersection in order to have violated the ordinance. A copy of a certificate sworn to or affirmed by a trained law enforcement officer or a technician employed by the City of Lilburn, and stating that, based upon inspection of recorded images, a motor vehicle was operated in disregard or disobedience of a circular red or red arrow signal, and that such disregard or disobedience was not otherwise authorized by law, is prima facie evidence of the facts contained therein. Prima facie evidence is that evidence that will establish a fact or sustain a judgment unless contradictory evidence is produced. Since the city carries the burden of proof, the city gets to present its evidence first. The city solicitor will call witnesses first. After a witness testifies, you have the right and the opportunity to cross-examine that witness. After the city's witnesses have testified and have been examined, then you will have the right to call any witnesses, and you will have the right to testify on your own behalf, and you or your witnesses also may be cross-examined by the solicitor. Please note that to cross-examine a witness is to ask that witness questions about the testimony they've already given, about other facts and circumstances that are relevant to the case being tried. Please also note that cross-examination involves asking questions and allowing the witness to respond. Cross-examination does not allow one to make a speech, to argue with a witness, to call the witness names, or tell the witness what you wanted them to say. Your questions may be leading. That is, they may suggest the answer you want the witness to give, but you must ask a question. The city, having the burden of proof, is entitled to introduce what is known as rebuttal evidence after it has presented its case and you've presented your case. At the conclusion of the presentation of evidence, the court will issue a ruling and enter its judgment. You have the right to appeal a judgment of this court, whose decisions are reviewable in cases of this nature by appeal to the Superior Court of Gwinnett County, under Official Code of Georgia Annotated Section 40-13-28. And even if a judgment should be rendered against you, the city may not legally undertake to enforce the judgment for at least 10 days after the date the judgment is entered. If you want to appeal my decision, please tell the clerk when you pay your fine, and she will hold your payment as an appeal bond. You may very well wish to speak with an attorney in preparing your appeal. Neither the court nor any employee may provide any legal advice to you. Thank you, and we will now proceed with the call of today's calendar.